So yesterday we have been discussing about the natural law, where Mr. John Locke is of the opinion that it is the social contract existing in between the individuals and the state that is making the state and the individual to have some kind of relationship with each other, and that relationship is having some limitations because the individual is not foregoing entire freedom to the state, only a limited freedom, where the internal protection and the protection from external aggression are the two things, and the state is not supposed to follow any commercial activity. Laissez-faire means the state is not supposed to take up any commercial activities. It has to only take care of the welfare of the subjects, that too protecting them from internal injury and external injury. So no economic activities. That was that period in between 1632 and 1704, and the way in which the public was expecting from the state, it has been reflected in observation of John Locke that the state is not to indulge itself in any economic activities. But the case is reversed now. The state is indulging in economic activities to its core nowadays, because of requirement or because of change circumstances, the change of political thought, everything. Then coming to another political scientist, Jean Rousseau, 1712 to 1778, he is of the opinion that this social contract concept is not at all a historical concept as propagated by Hobbes and Locke, but it is a kind of a just hypothetical conception. Hypothetical conception means it is nothing but being visualized by John Locke, being visualized by Hobbes. But in fact, have we ever seen that the public entered into an agreement with the state, that the public is foregoing some freedom to the state and the state is taking care of public? There is no such kind of agreement does happen at any point of time. So Rousseau is little bit more practical and is saying that no such kind of agreement is in between individual and the state, and the sovereign is acquiring its power, taking over its power by virtue of the will and wish of the public, maybe in the name of kingship, maybe in the name of elections, whatever the case may be. And that is how the state, after acquiring the powers of the statehood, it started discharging its function in consonance with protection of freedom and in consonance with protection of equality, because it should not have any discrimination against a certain class of people, and it should not have favoritism in respect of certain other group of individuals. And here Mr. Rousseau is of the opinion that the natural law, which says that all are equal, because the blood that flows in everybody and the various components that take the shape of a human being are one and the same. So 5 components, panchabhutam we say. So because of this concept of natural law, the freedom and equality of the individual is to be protected by the state, because the state cannot take away which the nature has given. So for him, state, law, sovereignty, general will, etc. are all interchangeable terms. So he is of the opinion, Rousseau is of the opinion that state is not in a position to make use of these things which are naturally made available to the individual. So state cannot take them, or state cannot restrict them, as the case may be. Coming to Immanuel Kant. So he is another political scientist who lived in 18th century, and he is of the he is having a perception about this natural law, stating that the basis of social contract theory was the reason, though it was not a historical fact as Mr. Rousseau was referring to, but it has got some reason why we are binding ourselves to the state. That bindingness Mr. Immanuel Kant is taking into consideration. So we are bound by whatever the state says, we try to follow. Why we follow? Because we are of the opinion that state will take care of us, and state also takes care of us because state feels that it is duty bound to take care of us. So there the Kant drew a distinction between natural rights and acquired rights, recognized only the former which were necessary for the freedom of individuals. So it is not the acquired rights based on which we can identify whether the particular subject is having the freedom or not, but it is based on the natural rights only. We can say that the respective subject of the concerned country is having the freedom or not. He favored separation of powers and pointed out the function of the state should be to protect the law. He propounded his famous theory of categorical imperative in his classic work entitled Critique of Pure Reason. So he tries to find the rationality. Why should we follow? Why the state is restricted? Why the individual is having the freedom? So for everything, he was trying to find a justification. So his categorical imperative theory is derived from Rousseau's theory of general will, and it embodies two principles. What are those two principles? One is that the categorical imperative expects a man to act in such a way that he is guided by dictate of his own conscience. So here, the natural law principle. For example, a child takes birth into this world. After taking birth into this world, he feels some kind of inconvenience because change of atmosphere inside the mother's womb and then. So when he was expecting some discomfort, expressing discomfort, so mother supports him by giving some kind of warmness, etc. So he feels some kind of happy, some kind of solace on account of such pain and all due to change. So like that, the man tries to make use of his consciousness and try to follow whatever his conscience says. So child's conscience says that this is not good for me. Immediately he starts crying. In the same sense, the grown-up man also tries to identify what his conscience is saying, and accordingly he continues to follow. So that the individual compliance of the natural law or individual compliance of rules and regulations as conveyed by the natural law or as determined by the natural law is referred by Mr. Immanuel Kant, stating that it's a categorical imperative. Categorical means specific. Specific direction given by the nature which is being followed by the man without anybody's intervention or dictation. So state need not tell every man, come on, you get up early in the morning, then take bath, then so and so, so and so. Because it is based on the consciousness, and that consciousness is guiding us with the help of the natural rules and regulations. And that is how we follow all these things. So they are all self-determined. Individuals follow themselves. But nowadays, due to this corona, state was made to give so many directions stating that maintain your immunity, wash your hands, close your nose, etc. But that means state is taking much care, I can say. The second principle expounded by Kant was the doctrine of autonomy of the will, which means an action emanating from reason, but it does mean the freedom to do as one pleases. What is this autonomy of the will? Nowadays, we make a general statement. I can do whatever I can, but I don't want to do it. What is this? I can do. For example, when I am saying that I can do, can I commit a murder on account of my personality? No, I can't. There are some people who can do all these things, but if our personality is not accepting, is that there an autonomy of the will? Am I in a position to do whatever I would like to know? My consciousness is going to restrict me, stating that you are not supposed to do those kind of activities. That means the second principle says that the autonomy of the will also being regulated by the natural law. So of course, the human being is having a capacity, competency to do, but at the same time, this autonomy of the will is regulated by the natural law. In essence, Kant held that an action is right only if it coexists with each and every man's free will. If my free will your free will and the other person's free will are able to coexist with each other. If I say that I want to murder you, your will cannot coexist. If I say that I would rob you, your free will not be existing. If I say that you also survive, I will also survive. The third person also will take care of his food, clothing, everything. So then all of us are able to fulfill our wills, and not only that, they are all coexisting with each other. And such kind of coexistence is the right action, and according to the universal law. So when we are all able to feel for each other, we are all able to allow each other to fulfill their reasonable expectations, justifiable expectations, that kind of natural law is the law referred by Mr. Immanuel Kant, stating that it's a categorical imperative. We are not prescribed with to cause harm to others and thereby survive ourselves. Even an animal is not given such kind of a rule. But there are some people who adversely criticize the concept of lion killing the animals to suppress its hunger. And in the same sense, human being also can rob the property of others, can kill the other person and then survive. I am a tiger, I am a lion. But it is a wrong notion. That is what here he is saying, that we have to coexist. There, the lion killing the certain animals, it is a natural phenomena that is prescribed to regulate the population. And in fact, if we see the ecosystem, these are the herbivores who can eat the animals and survive themselves. And if you say decomposers, the vultures, so they are born and brought up for that purpose only, to see that the dead animals are being eaten by them. And once again, all those dead animals, after they taking them as a food, and that will, after the death of this vulture, once again all these carbohydrates, nutrients, phosphates, everything, and once again they join the earth. It is a cycle. We have to understand in that sense only, but not in any other sense. So we have to make use of these natural principles to coexist with each other. That is what Immanuel Kant was referring to by finding out the reason. Because we started our understanding by questioning every dictation or every instruction to follow only when we find that there is a rationality, there is a justifiability. So when we are trying to start moving ahead step by step, we are trying to find the reason. So initially we were under the impression that natural law is to be followed as it is, no question of questioning, etc. But you see, as we are moving ahead, we started finding the reason. So naturally, there was a little bit hostility that was being developed against the natural law. So almost all in the 19th century, people started finding out the reason, and wherever they couldn't find their reason within their within the reach of their capacity, so they started saying that no, natural law is not a thing which is to be followed by the modern man, because modern man has got so much of intelligence, etc. But once again, now if we come back to 20th century, because we have seen so many bad things here in 19th century, world war, so on and so forth. So once again, people started referring to, so you see, the World War I made us to understand what is happening and where we are committing our mistake. And then Mr. Rudolf Stammler, Professor Rawls, Professor Kohler, etc. They started once again propagating about the natural law. And there, Rudolf Stammer and Professor Rawls, Professor Kohler, they step by step, they are making us to understand the significance of the natural law once again, stating that the natural law will make us to have the thought about the community. Natural law will make us to thought about the respect which we need to give to every other item in the nature. So like that, we, instead of I, we, the phraseology we is to be given an importance. That is how they started guiding us or suggesting us. Then equality of right to secure generalized wants. So everybody is to be given liberty opportunity, power, minimum means of subsistence, and then social and economic inequality. And Kohler also, he started saying that the standard of conduct which in consequence of inner impulse. So here also he is just trying to respond to the consciousness. So consciousness, whatever our consciousness. So some people, when they make some kind of strong statement, immediately the other person will respond, come on, please search your consciousness. If that consciousness is there to suggest you to make such kind of harsh statement, you can continue. Immediately this person start thinking. So that means consciousness will not suggest like that. It is all emotional imbalance which makes us to make harsh words, etc., etc. Then Lon Lewis Fuller, he is of the opinion that the natural rights will take care of us in all its aspects. For example, he says that he found a family resemblance in the various natural law theories. So he is, whether it is a social contract, whether it is a general will, whether it is a imperative, whatever the case may be, but all these things are collaborating and they are working out only to make us understand the importance of the natural law. That is what Fuller is able to consolidate all the theories pertaining to the natural law. And Mr. Hart also, because Hart is of he is a person belonging to positivistic school. Positivistic school means they are of the opinion that command should always be from some sovereign authority. So king should guide, or government should guide us. Then only we have to follow. And such kind of heart, the person who is propagating or who is believing the positivism, he is critically analyzing the formulation of Fuller, stating that the national law, the law of the respective state, is to be received in the form of substantive rules. Substantive rules means which determines the rights of the parties. So the state is going to identify which right is to be given to its subject, which right is not to be given. So that means he is trying to interfere with the natural law principle, stating that unless the natural law is accepted by the state, all those natural rights will not be available to. So that means the state is given some kind of prima facie position to determine whether all the natural rules, rights, etc. can be given to its subjects or not. So that means a discretion is made available because he is of the opinion that if all the rights are given, people may not be able to make use of it. That is what now we are finding so far as India is concerned. So at the time of framing our constitution, Professor Weir, W-H-E-A-R-E, he has observed that the Indian constitution may not be suiting the Indian subjects because of their temperament and all. And even in what is that case, Aruna Shanbag case, the Supreme Court also has observed that the Indian doctors, if given the power of euthanasia, they may be emotionally exploited, economically exploited. So doctors may be forced to give a decision to kill a person by passive euthanasia. So their Supreme Court also said that no, Indian public are not suitable and they may not be allowing the doctors to take independent decisions. So it said no active euthanasia, only passive euthanasia, that too upon the decision from panel of doctors. So like that here, the Hart is also opinion that state will decide, state will determine what are the rights to be given. So rights will be identified by the state, though they are naturally available in as per the natural law school. Then Finnis, he is another scientist, political scientist. He is saying that natural is the set of principles of practical reasonableness in ordering human life and human community. The basic principles of natural law are pre-moral. So here only most of the jurisprudents are having some kind of different understanding. So they are of the opinion that these natural law principles are pre-moral. And once they are identifying them as pre-moral, they are contending that morals are nothing to do with law. Morals are nothing to do with law. But there only, I think there is some kind of unnecessary deviation that has taken place. And they said that these basic goods are objective values in the sense that every reasonable person must assent to their value as object of human striving. So that means they are leaving these morals to be followed or not to be followed by the individual. But I personally feel that it is not the morals that are to be determined by the individual. If I don't want, and I would like to stay back in this particular society, is the society going to stay safe if I start following immorals? Definitely no. I will be a harmful subject to the society. So I am of the opinion that morals are to do with everything, and they are not only pre-moral, they are also into legal. But for the morality only, we are identifying certain wrongs as civil, certain wrongs as crimes. So here only the British jurisprudence says that morals are nothing to do with law. But ancient Indian jurisprudence says that it is only the moral that is the base for which or over which the law is developed. The law has taken its present shape. So here we can conclude this understanding about the natural law saying that the brief survey of natural law has varied from time to time. So at one point of time they had some understanding, at another point of time they had a little bit different understanding, and that is how understanding has been changing from time to time. It has been used to support almost any ideology, absolutism, individualism, and has inspired revolutions, bloodsheds also, both positive and negative we had. It has greatly influenced the positive law and has modified it to a considerable extent. So even the positivistic school people also started adopting that, yes, there is something which can't be identified by the state on its own. So it has to take something from the natural law only. The law is an instrument not only of social control, but of social progress as well. It must have certain ends. A study of law would not be complete unless it extends to this aspect also. So the natural law theories have essentially been the theories regarding the ends of law. The natural law principles have been embodied in legal rules in various legal systems and have become their golden principles. That is why whenever we are enacting a law, the best example is Indian constitutional law. We say that we would like to achieve in the preamble sovereign, socialistic, so on and so forth. Then equality of justice, political, economic, etc. So the social progress also is the basic motive behind prescribing the law, and that law has its roots in the natural law as believed by the natural law school theories. So here the answers are given. Immanuel Kant, he was supporting the natural law but with some understanding. John Rawls, he was supporting the natural law with some understanding. Stamler also, he was trying to find out the reasoning behind it. So all these three people are the followers of natural law. And who is hostile? Jeremy Bentham is the hostile to the natural law school, and very particularly because Jeremy Bentham is of the opinion that it is a utilitarian value of the law. If the natural law is not useful, we can discard and we can start a new law to be given in the to be given to the society by the state. That was the understanding. If a law is not useful, better we discard it. But if we come to the ancient Indian jurisprudence, every law is useful. The only thing is that we may not be able to identify their usefulness. But all these jurisprudence, we have to understand only in the light of the Western jurisprudence only. And there is no link of these Western jurisprudence made with the Indian jurisprudence. I don't know the reason why, but let us not take the ancient Indian jurisprudence and understand these things. But to have a further clarity, I have taken the examples of the Indian jurisprudence, but because these are all the people belonging to Western countries only. And now I will go to the next question, that is where Match the following. Match list 1 with list 2 and select the correct answer using the code given below. So list 1 is talking about providing the list of various theories, and list 2 is providing the various jurisprudence. Mr. Pound, Mr. Bentham, Mr. Ihering, Mr. Comte. And the theories are utilitarian individualism, social utilitarian, scientific positivism, social engineering. So we have discussed, the first question we discussed was scientific positivism. It was Comte, isn't so? So the third one, C, is nothing but fourth option. If we see C, the fourth option. So here it may be this one or this one. And let us try one more. Then utilitarian individualism. Utilitarian individualism is Bentham, because we have discussed it number of times. So first one is A is 2. So A is 2. So automatically the third option gets
ABCDMO paina 1 2 3 4 ikkada ante first question ki okay ila match chestunara.
So utilitarian individualism A ka sir, A nunchi ila chudali. We have to verify. A vachesi 2 Bentham. So Bentham, this is right. Scientific positivism, we had understanding already. Comte 4. So because these two things have matched, automatically rest of the things also gets matched. That is
madam, it got exam lo 1 mark for the correct answer, 1/2 mark for the wrong answer.
Negative answer unda sir?
No, undi.
Unda, okay. But half anukunta negative ki.
నేను ఈ వారం ఎండ్కి మంచి రోజు చూసుకుని ఆ రోజు ఫిల్అప్ చేస్తాను, ఎందుకంటే మార్చి 1వ తారీఖు వరకు ఉంది.
Okay. So here I have posted the material, links, sources for utilitarian individualism. Light ga content petanu. Then I have posted the links. What happened?
Hello ma'am.
Edo miss ayindi sir, edo press ayindi. Yeah, so I have posted the sources here also. So you can read. We have discussed scientific positivism earlier, so that is why I have not posted the link pertaining to scientific positivism. But the rest, Ihering's theory, social engineering theory, utilitarian individualism, those 3 schools I have posted the links also for much more reading and all. Then coming to another question, do I need to discuss that little bit more?
వద్దమ్మా, వద్దండి.
Okay, right. Then
ఇది నేను ఏంటంటే కొన్ని పేపర్లు ఎప్పుడైతే చేయటం మొదలెడతానో అప్పుడు కనుక ఏమైనా మిస్ ఉంది అనుకోండి, అప్పుడు మళ్ళీ నెవర్ వేసుకోవడంలో ఐ థింక్ ఇట్ ఈస్ బెటర్.
Yes. So దాంట్లో ఒక UGC net లో ఒక ఆప్షన్ is also there sir. They will only provide the question papers if we paid 99 rupees or so.
ఎస్ మ్యామ్, యాక్చువల్లీ నేను ఏంటంటే ఇప్పుడు ఫస్ట్ మీది ఇప్పుడే స్టార్ట్ చేశాం కదా సెషన్, ఒక వారం 10 రోజులు కంటిన్యూస్ సెషన్స్ అయిన తర్వాత నాకు కొంచెం కాన్ఫిడెన్స్ వస్తుంది కదా. దాని లోపల యూజీసీ నెట్ డిఫరెంట్ క్వశ్చన్ పేపర్స్ కూడా కొంటారు. అప్పుడు ఈ వారం ఎండ్కి నేను ఏ రోజైతే అప్లై చేస్తానో మంచి రోజు చూసుకుని కదా అప్లై చేసేది, దాని తర్వాత 95 రూపీస్ కూడా అక్కడ సబ్స్క్రైబ్ చేస్తాను.
అవును అప్పుడు సో దట్ మనకి ఏంటంటే డిఫరెంట్ పర్సెప్షన్స్ లో క్వశ్చన్స్ ఇచ్చినా వీ కెన్ ఆన్సర్ అనేది కాన్ఫిడెన్స్ డెవలప్ అవుతుంది.
అవును అదే.
So next question is, which one of the following sources of law has the basis under Article 141 of Indian Constitution? So we know basically 141 of Indian Constitution as a provision where the law determined by the Supreme Court is binding on all the courts. The provision 141 em cheptundante ikkada, I'll take you to the provision. We'll read. Law declared by Supreme Court to be binding on all courts. The law declared by the Supreme Court shall be binding on all courts within the territory of India. So it says only the statement, that's it. It is binding. In the jurisprudence, we are going to find out what is the ration. What is the rationality behind declaration? So is it because supreme legislation? Is it because subordinate legislation? Is it because colonial legislation or is it because precedent doctrine? Because we know thoroughly the doctrine of precedent, we say that 141 is based on the doctrine of precedent. So I'll just give a small discussion here. Supreme legislation means the legislation which is supreme by all means. And in fact, here the judiciary is not making the law. It is completely ruled out. So judiciary is giving orders based on the facts that are adjudicated before the Supreme Court. So it is not at all a legislation. So this option is ruled out. It is neither a subordinate legislation because it is not at all a legislation. And it is no more a colonial legislation also. But here we need to get a little bit clarity. There are some
subordinate and colonial legislation ante basically aim meaning ikkada. What does it mean?
Subordinate legislation ante the rules that can be framed by the executive, which is subordinate to the plenary agency of legislation. That is parliament ki will subordinate. Parliament will determine the basic policy. Accordingly, these people will frame rules.
Okay.
So that is subordinate legislation. Parliament is supreme authority to make the laws. Executive is subordinate body to make the laws in the light of the direction given by the legislature.
Okay.
And colonial legislation means, for example, British India was having various legislations like Indian Contract Act, Indian Penal Code, and the British Parliament, through certain agency created for making the laws to the British India, they were making the laws. That is called as, India was called as Dominion of India. So all those legislations were colonial legislations, but subsequently now we have accepted them by virtue of Article 372, and all those legislations have become now the Indian legislations. But previously they were all colonial legislations. Nowhere the judicial this thing. See, here I would like to take you to one point. Some professors do consider for example, Vishaka case, where Supreme Court has framed certain rules to be practiced in workplaces till the law is made by the Parliament in consonance with CEDA Convention. So some people argue that it is a judicial activism. Law is created by the judiciary and antaru, but I don't agree. The reason being, it's not first of all, the judiciary is not an agency to make the law. It's an agency to dispose of the litigation. And the another reason in which I will support in favor of my statement that Article 51C is there. According to Article 51C, the state has to foster the respect for the international treaties, conventions, etc. So that means we have to respect international treaties, etc., which we sign. And state means all the three agencies: legislature, executive, and judiciary. When state is bound by the international conventions, when CEDA Convention is signed by the Indian state, it is binding even the judiciary. The only thing is that it has applied. So simply for application of the law which is
CEDA, is it binding with the Indian nidhi? Ante CEDA gani idi kada external ఇదైంది కదా, అంటే వాట్ డు యు సే, బేస్డ్ ఆన్ విశాఖ వర్సెస్ స్టేట్ ఆఫ్ రాజస్థాన్ కేసు, సీడా వాళ్ళు ఇంటర్వ్యూ అయ్యి వాళ్ళు రికమెండ్ చేశారు. సో ఇట్ ఈస్ అన్ ఐఎల్ఓ కదా, ఐఎల్ఓ కన్వెన్షన్ నుంచి వచ్చింది కదా మేడం.
సార్, ఇప్పుడు ఇండియన్ స్టేట్ హ్యాస్ signed that particular convention.
Yes.
And once the state has signed the convention, according to the Indian constitutional principles, it is binding us.
Oh, correct.
The only thing is that under 243 of Indian Constitution, the state, the Parliament has to make law in consonance with that international convention.
Yes. Article 272.
243.
Article 243. నేను రాసుకుంటున్నా, మీరు మాట్లాడేటప్పుడు రాసుకుంటున్నా.
రాసుకోండి. 51C and 243. Ante 50% international treaties are law already. The only thing is that it is to be given a shape as under 243.
Okay.
Simply because the law has not been given, the law which the Indian state has signed in the name of treaty has not been given the Indian legislation shape. It does not cease its operation in Indian legal system by virtue of 51C.
Yeah, okay. Okay, got it.
So by virtue of those two reasons, I am of the opinion that judiciary has not made any law in that regard, but simply it has adopted the law, applied the law, gave some guidance. That's it.
Okay.
As an expert body, as an apex authority, as a guardian of the constitution, it has given guidance. That's it. Then
Yes.
shall I proceed with the next question?
Yes, ma'am.
Yeah. Then which one of the following juries is not related to historical school? Savigny, Eldridge, Henry Maine, and Hegel. These are the four personnel who are given to us, among whom we should identify who is the person not connected to historical school. So when we need to identify who is the person not connected to, better we discuss the historical school. Shall I take you to that school?
Yes, ma'am.
Yeah, this is the e-Pathshala notes which I could able to secure with reference to historical school. And this is prepared by the National Law Schools. Mr. Ranbir Singh is principal investigator here. Sri Krishnadev Rao is paper coordinator, and Haider Wali, professor of law, National University, Odisha. She has written the content, and the content was reviewed by Gangotri Chakrabarti, North Bengal University, Siliguri. So I'll, with the help of this material, I'll take you there. Here, the prerequisites, background of positivist thinking of law would help, because already we had the natural law school discussed, and then we have also discussed scientific positivism. So that understanding is sufficient to understand this historical school. Then the objective of this school is to discuss the main tenets, spelling mistake, historical school of jurisprudence, to elaborate upon theories of Savigny and Sir Henry Maine, and to understand the significance of historical school. We'll start with the introduction. So the main proponent of historical school is
Madam, note పెట్టారా అక్కడ ఈ నోట్ గూగుల్ డ్రైవ్ లో ఉందా
ఈ లింక్ ఉంది సార్
ఉందా ఓ లింక్ క్వశ్చన్ పేపర్ లో ఇచ్చేశారు ఓకే యా క్యూపీలో యా రైట్ గాట్ ఇట్
ఇప్పుడు ఈ పాఠశాల ఉంది కదా ఈ పాఠశాల లింక్ మీకు ఇక్కడ ఇచ్చాను చూడండి ఇది ఇక్కడ ఇది
yes ma'am
మీరు ఇప్పుడు ఇక్కడ లింక్ క్లిక్ చేస్తాను you will come to know.
Yeah, it's okay ma'am, it's okay, I can navigate. Yeah, మీరు టెంపో ప్రొసీడ్ అయిపోండి కరెక్ట్ గా చెప్తున్నారు
రైట్ అంటే అది డౌన్లోడ్ చేసి PDF లో పెట్టా ఎందుకంటే అది అక్కడ స్క్రీన్ మొత్తం కనపడదు సార్ ఇప్పుడు ఈ స్క్రీన్ ఓపెన్ చేశాను అనుకోండి నేను మీకు చూపిస్తాను So here it opens like this. Here I need to select advanced jurisprudence, and then here I need to select historical school. This is historical understandings of the law. So it will open, but the thing is that it will be difficult for us to discuss directly. It will this kind of screen will block the content, the same content. You see, Haider Wali, she is the writer, the same content. The only thing is that I got it downloaded. So here there is an option to download. I got it downloaded and saved in my laptop, the same content. So better we discuss here then, because it fills the screen. I thought of sharing the PDF. So the chief exponent of this historical school is Frederick Cary von Savigny. He is universally recognized as the founder of historical school of jurisprudence. He emphasized that for a proper understanding of law and legal institutions of any country, it is imperative to take into account history as also the society where the law and legal institutions have to operate, since these were closely interrelated. So where this concept of history comes into Savigny's proposition of jurisprudence, he is of the opinion that without knowing the history of the respective country, without knowing the history of the respective society, whose law, whose legal institutions we would like to understand. For example, if somebody wants to understand about the Indian legal system, they should know the history of India. They should know the history of Indian legal institutions, like what is the Indian state now, previously who were governing us, then how come such kind of governance got changed to democratic form of governments, because the law has got link with all this history according to Mr. Savigny. So without that basic understanding, we can't have the better understanding of the law of the concerned nation and the legal institutions of such concerned legal system. So Indian judiciary is to be understood by us. We need to look into the historical perspective as to how it was a high court, then from high court they changed as a federal court, and then once again Supreme Court, and now once again we are having the Supreme Court. So how come all these things have got updated? We are required to know. So that means history has its relevancy with that of any law or any legal system, as the case may be. Then how he is able to have such kind of understanding? What kind of background was there behind Savigny's perception that history is the base, and without knowing the history, you can't learn about a law or about a legal system, as the case may be. Generally speaking, historical school is the product of German juristic thought. So this understanding has taken its thought or origination in German juristic understanding. Earlier, Edmund Burke had emphasized the importance of history, and Hegel had propounded the view that state is an organism whose constitution is determined by the political consciousness, that is, oak of the public, Oakes' theory. Popularly, we will find this kind of short notes, Oakes' theory. Oakes' theory is nothing but the voice of the people, the consciousness of the people, the political understanding of the people. So which has taken the shape, a kind of a governance. So the will of the people, when the public are of the opinion that please, Mr. State, you govern us, automatically the state is taking the role of the governance. So without expectation from the public, definitely the state cannot continue its function with reference to such people. So in that regard, we can say that the will of the people is making. If you take the Indian preamble as a best example, we the people of India have given ourselves the constitution, and accordingly we are able to be governed by the Indian constitution through the people with whom we select from time to time. So here each institutions, namely law, state, etc., they are taking the participation, and they are gaining the spirit and the determination only with the help of the will of the people. So nowadays there is some contention saying that because the Indian public do want these corruption practices, the politicians are practicing. So we are only making them to follow this. So that means the will of the historical school perception is right in that context. If we don't want, the politician cannot follow. So here, the other factors which contributed to this stream of thought were reaction against natural law, and the French Revolution. So basically here, the suffering they had, which made them to enter into French Revolution, the phase of French Revolution, that was the a kind of a negativity they got developed in respect of the natural law, because the capitalists who were concentrating the wealth in their control and making the labor population suffer on account of these tendencies of the capitalists. So the people were of the opinion, the scientists were of the opinion that why these natural, the capitalists could able to acquire, then the rationality supported by the capitalists is that we are born like that, we are capitalists, we are given wealth by the God, that is why we are able to control you. There the people got some kind of adamant attitude towards the natural law. So that was a kind of, that means the suffering which they got and the suffering which made them to enter into French Revolution phase has made them to move a little bit away from. So it is like a hatred towards the natural law. And they started developing a new kind of analogy, new kind of ideology. The other principle or other thought is that the spirit of nationalism and post-revolutionary romantic revival in Europe. So after the revolution, so they were almost all reverse. That means previously it is the capitalists who are having the government in their control, and now it is the public who are able to have the control over the government. And once a kind of power is given to the labor, so initially it was some kind of tussle also. They couldn't manage and everything. They were having post-revolutionary this thing, some kind of ups and downs were there. And both these kind of concepts made these jurisprudence, certain jurisprudence, to say that no, we have to study how the French Revolution has taken place, what made us to become these kind of revival procedure and all. So that means history has to do something with the jurisprudence. That is how history has been linked to the jurisprudence. Then how it is linked, we'll see step by step. Montesquieu is one of the political scientists whose lifetime was from 1689 to 1755. And this person has contributed much so far as this ideology of the historical school is concerned, having been a native of the France country, and through his classical work by name Spirit of Law. That the Spirit of Law is a book which got published in the year 1748, and that Spirit of Law is able to give us exactly the perception with which Mr. Montesquieu was referring to the history, having its connection with the jurisprudence. He attributed evolution and development of law to the effect of cause and effect in a given social surrounding and biological environment. So because he is a person who belongs to France and he had been the close observer of the French Revolution and the rationale behind the French Revolution, the changes that were brought in the society and all. So he was able to say that the society will automatically will have evolution. So that means it will come into existence, and having come into existence, it will try to develop. So during the process of development only, these kind of things like cause and effect. So when they were suffering with the help by virtue of the despotic rule of the capitalists, so they have had an impact, injury. That injury made them to identify that no more capitalist rule, and the labor should occupy the governance. So it's a cause and effect concept which made the development of the law in the given region. In the given region means keeping in view the surroundings of that legal system, keeping in view the biological environment. So how the France was facing these kind of issues and all. So that means the region has got its link with the legal system by virtue of its progression from time to time, or regression from time to time, whatever the case may be. He held that law should be adopted to suit the people for whom they are framed, keeping in view the degree of liberty which Constitution desired to grant to its people. So Mr. Montesquieu is of the opinion that ultimately the public are to be given the priority. So public should be given based on the document that it has deciding that this should be given to public, this should not be given to public, etc., etc. So that means the state is also bound by the Constitution. According to him, there is nothing like good or bad in law, as it essentially depends on political and social conditions and environment prevailing in the society. So he is not attributing the negative consequences of law to the law. Rather, he is able to identify that it is not the law that is good or bad, but it is the people, or it is the conditions, political, social, and environmental conditions that are making the law to get its purpose defeated or to get its purpose successful, whatever the case may be. So Mr. Professor Weir also, he said that the Indian Constitution can be used for the best democratic form of government in India. The same principle, same constitutional provisions, and the same can be used in a reverse manner also. So we have seen Mr. Gnani Jail Singh use the same constitution to impose the emergency. And the same constitution is used by Mr. Abdul Kalam to see that the young minds of India are ignited towards the innovation and all. So constitution is one and the same, but the people who are executing those constitutional provisions may change this concept into any form according to their this thing. That is what Professor Weir, the world famous constitutional expert, was referring to with reference to Indian Constitution. Then coming to Edmund Burke. So his lifetime was from 1729 to 1797. He considered evolution of law as an organic process and an expression of common beliefs, faiths, and practices of community as a whole. So here, Mr. Edmund Burke, because he got a little bit advanced time, so Montesquieu was initially, so 1689. So that means a little bit period moved ahead. So he could able to have some kind of better understanding with the help of the Montesquieu's proposition about historical law, historical school, and he wrote another book by name Reflections on the Revolution in France. So that means almost all these historical school jurisprudence, they were looking at the French Revolution because it has created a lot of havoc in the minds of the public and in the suffering in the daily life of the people. So reflections, that means post-revolution, the period was critically evaluated by Mr. Edmund Burke, and he could able to identify that the customs, the traditions also will play a major role in the development of the law. So that means, for example, if you take Hindu law, Indian Hindu law, so we do accept the customs. And if we take the parliamentary proceedings and the presidential this thing, we follow the traditions the UK was following. So the customs and traditions can't be kept completely away from the law. Moreover, they do participate in the growth of the law, and from step by step, we try to improve upon those customs. For example, if we take Muslim law custom of pronouncing the talaq by name talaq, talaq, talaq 310, it is a custom. But when that custom is taking the violent shape, where they are not following the true tenets of the Quran, then we have insisted that if the system provided in Quran is not followed, that is Shariat law is not followed, we are here to impose the criminal liability. So the custom is only upheld, but it made us to go even by prescribing the criminal liability. That is how Edmund Burke was referring to, stating that he could able to identify that the customs and traditions do take their role in the growth of the law. He upheld the significance of English customs, habits, and religion in the evolution of law, and denounced the French Revolution for its catastrophic consequences. So, sitting in kind of understanding, so he is trying to have a comparison. He was looking at English law, he was looking at the scenario that is available during the French Revolution. He could able to say that no, English law was good enough to some extent because it is following some customs, there are some habits, religion, etc. But in French Revolution, it has created a havoc in the public social life, public life, etc. So this is not right, this is right. Why? Because it is right, because they were following customs, they were following the traditions and all, etc. So that means he was trying to find out the positive steps that can be adopted to come out of the negative impact which the pre-French Revolution scenario has created, and he wanted to support the post-French Revolution to see that it is once again coming onto the track. So during that process, Edmund Burke was making all these kind of propositions in his reflections on the revolution in France. Then coming to reaction against natural law thinking. Why these historical school people were not happy, were not comfortable with that of the natural law thinking? Because during the 17th and 18th century, the people, on account of the various reasons which they were surviving under, like French Revolution, etc., it made them to develop some kind of a negativity towards the natural law. And the predominated writers belonging to this school of thought relied on reasons. So they were trying to find out the reasons, because this is not there, this reason is not there, so this is not to be accepted. So social reasons, historical reasons, and other factors. So that means it's like they are trying to evaluate the existing legal system. They are trying to find out which law is good, which law is bad, why it is bad, why it is good, etc. So during this process of evaluation of the existing legal systems in various countries around their surroundings or across the globe, as the case may be, mostly they have visualized only Western countries. They have not come to South Asia or like that. This was the perception they could able to develop, that natural law is not right. It is the historical law, historical perception that make us to develop the law, grow the law, consistently comply the law. Friedman quotes Barker, who observes that the historical school represents a reaction against natural law, a reaction against rationalism, its universalism, and its individualism. So they were not somehow, simply because today, for example, most of us would be facing the difficulties in our lives. Definitely, one day will be difficulty, one day we will be good. But simply because the difficulty is there, are we going to criticize the nature, stating that difficulty has been given to me, so I'll shift my religious faith from Hinduism to Christianism or something else? We don't do. Why? Because we believe that hardship is also part and parcel of our life. But here it is not so. They were trying to find out the reasons. When they couldn't find any reasons in the natural law, they started doing something else, trying to find out something else. During that process, only historical school came into existence. Thought of historical school came into existence. The natural law thinking, with its emphasis on the ideas of liberty and equality, culminated in the French Revolution. So that means their entire focus was only French Revolution. Not only this, the disastrous consequences followed in French, which led in England to denounce the excesses of the revolution. So the impact of the French Revolution in England also made them to have this kind of perception. He emphatically advocated the importance of history, habit, religion, tradition, and gradual growth as the real guide for social action. So that means he was trying to find out, oh, because we are having problem here, let us take a new way, let us take a new route. So it is like some of our Indian philosophy says that it is nothing but escapism. It is nothing but avoiding. We can't avoid. But they were of the opinion that they can avoid and they can find out a new way of life and a new way of legal system. And during the process of finding out the good system, they have adopted this historical perception. In Germany, a similar reaction against French Revolution was spearheaded by Mr. Savigny in the field of law. Apart from other factors responsible for the reaction against the French Revolution and all other natural law thinking that understood, if there was also the fear that the spirit of French Revolution might spread to other countries in Europe. So that means that was the another apprehension they were having, stating that if we don't deviate ourselves from this concept of natural law, philosophy of natural law, we also may be made to face the revolution that happened in France country. So automatically all these legal experts sitting in their respective countries started propagating some new theory stating that no, this is bad. This is bad. So they started making the people to take into a new kind of thought so that they change their attitude and they don't adopt the French Revolution mechanism in their respective countries. It was this protective thinking which inspired and motivated the jurists and rights belonging to historical school. So that is how it was almost all like after suffering, they got themselves changed their attitude with an understanding that because of natural law philosophy, all the suffering they were made to undergo, especially in the name of French Revolution. And that is the point where the new thought historical perception has been developed by Mr. Savigny, so on, so forth. The spirit of nationalism and post-revolutionary romantic revival in Europe. So this is how in Europe also all these kind of new attitude, new perception, looking into history, looking into background has started in Europe. And that is what here being referred to by Mr. Professor Stone. He is observing that Europe was passing through a post-revolutionary romantic revival. Victor Hugo's work on Roman legal history, Scott's historical novels, Splitter's and Hegel's philosophies of history are some instances of that wave of revivalism. Hegel had emphasized the doctrine of state as a living organism whose constitution is determined by political consciousness of the people, the vogue, that is, vogue means voice of the public, and whose destiny lies in the hand of history. So because the public had revolted in the France country, which also we call it as French Revolution or Industrial Revolution, here also public may revolt. That was their apprehension. That was some kind of fear they were having. So they wanted to take a new turn. They wanted to take a new philosophy so that the public are being given a new thought of understanding so that they don't revolt against maybe the capitalists or maybe the state in any other form. Rousseau's writings had emphasized the mysterious entity of group will or collective will, which, like those of Hegel, reinforce the nationalistic development of law and legal institutions. So they started making the people to develop the affiliation towards the country, towards the state. That is, nationalistic thought has been created by these people through their respective writings, Rousseau's writing, Hegel's writing, stating that we all should come together, collective will, group will. So we all should support our nation. So a kind, just like during our independence, as we were having the collective will towards the independence, there also they have developed the new philosophy in the minds of the public, stating that we should all have affiliation with our nation, state, etc. This spirit of nationalism surfaced itself more visibly and predominantly in Germany because the peculiar setting of circumstances. So the entire Europe country was moving towards this kind of historical perception. But while it is so, Germany was in a different context. The conditions in Germany were a little bit different, and how Germany got reacted to this kind of spirit of nationalism. Napoleon I had conquered many of the German states. He sought to enforce the French civil code in these states. He wanted to have some uniform civil code, just like India was having under its Article 42, that 70 years gone, but till today we couldn't execute the same. Napoleon was defeated in 1813. This provided an opportunity to know about the French civil code as a part of the conqueror's chain, and proved as a commenting force for the German states to unite for rejecting the code and for evolving a law more suited to Germany. So what this Napoleon's code, French civil code, though after the defeat, people started looking into why he tried to brought that French civil code, what was his intention. So when they were trying to analyze the respective French civil code after his defeat, they could able to have some kind of understanding that that French civil code was towards bringing the nationalism concept. So he wanted to unite all the states and see that to have the uniform law for all the states who he conquered. So the wave of nationalism, as it was there in French civil code propounded by Mr. Napoleon I, and all these kind of understanding started developing in the country, Germany, and this gave rise to the urge for legal and political unification. So when the civil code is being proposed for the public to have their respective civil rights protected, automatically it has taken in other fields also, like legal, like political also. They wanted to have one, let us all unite, let us have common everything, like that. It was at this time, to be more precise, in 1814, the Professor Thibaut published a plan for a single unifying code to be prepared by an interstate committee of jurists and practitioners. So Professor Thibaut, he has he got published a particular plan stating that with the help of this plan, we will have the single uniform code, and that code will govern us so that we all will be united together. So Thibaut's proposal was promoted by the almost bewildering state of the law in Germany in the early 19th century. So they were all feeling comfortable with his proposition. In some of the German states, Code Napoleon had been voluntarily adopted. So there was a kind of division of thought. So in some countries, they adopted the Napoleon Code, and that is what uniform French civil code, like that. And while in others, it was imposed by Napoleon as a conqueror. So in some countries, some states, it has been accepted voluntarily, but in some states, it was forced. Roman law had taken such deep roots that it was accepted as the common law. So that is how the Roman law has entered into the Germany, and the Germany was trying to adjust to that kind of law. In some states in the form of voluntary adoption, in some states it was as forced one. In the absence of any express enactment, in addition to that common law, imperial German statutes and German customary law also prevailed. So naturally, when there is an absence of law in certain areas, whatever the law that is available, we try to adopt. So in that case, because that the Napoleon Code and all were not taking care of everything, and common law is not able to take care of all the matters. So imperial German statutes, German customary law also has been given the shape of a law. So at some this thing, Napoleon Code is prevailing so far as common law is concerned, and in the rest of the areas, the imperial German statutes and German customary law is also governing the Germany. There was no uniform body of law which applied to all German states. So they were having some kind of discrimination. Thibaut therefore advocated the adoption of uniform civil code. So because all were not united to have the common law, so the Mr. Professor Thibaut, he was recommending, he was advocating, he was trying to convince the people, stating that better we don't have diverse systems of law, we may replace them with some uniform laws by adopting the native customs. Native customs means not the Roman law, but the German law. He wanted to give the priority to the German law. Savigny opposed the idea of Thibaut. So Savigny was not happy with this kind of ideology and the idea of Thibaut. And in his paper, he has mentioned his opposition, stating that the paper titled "On the Vocation of Our Age for Legislation and Jurisprudence." So Savigny is of the opinion we had already a suffering, so let us not have much more suffering. But whereas Thibaut is of the opinion that anyhow we have suffering and we are trying to enter into a new avenue of law. While entering into new avenue of law, let us determine something what should be there for us in future. So there only their thinking process got little bit deviation. The impact of the paper was so profound that it delayed the codification in Germany. So Savigny was opposing Thibaut. Thibaut was advocating for common law. So this idea of Savigny has reached the public in such a way that they were not completely satisfied with Thibaut, completely satisfied with Savigny. So thereby there was a delay in codification in Germany of the laws, almost all for a half century. Savigny also reacted against the trend of thought represented by the natural law school. So they were not happy with natural law as a whole. He emphasized that law is shaped by internal silently operating forces like custom, history, national spirit. So Savigny is of the opinion that everything will not be determined by the law, but it will be determined by the custom, practices, the national spirit, etc., etc. For example, recently during this corona, we were all having some kind of negative observation for negative idea for purchasing the Chinese products, simply because China
Yes.
has facilitated this coronavirus to spread in the entire world. But after 6 months or so, once again we started purchasing those products. So that means it was a kind of a temporary thought process changing. That is what Savigny is referring to, stating that we develop national spirit. All these things are not always being guided by the law, but they are all inherently operated forces, internal operated forces inside the public, and that will be automatically followed, and there a kind of tussle that may takes place whether to follow these German customary practices, etc., or to receive something from the Roman law on account of the French Revolution that happened there, etc. So in this way, there was some kind of a thought process which got developed, and the basic tenet or approach of historical school led by Savigny can be understood in this particular fashion. It is in the form of a table. So historical school, law is found, it can't be made. It does not consist of an abstract set of rules imposed on society by any political or other agency. So law is already there. The only thing is that it will be developed on account of the political scenario or the social scenario in that particular country. That is what historical school understands. It also understands that law, like language, grows and evolves and has deep roots in the social, economic, and other factors. So you can't be away from the respective society. It's like a language. Law is nothing but a language according to historical understanding. Laws cannot be of universal validity. So they are of the opinion that laws cannot be having a universal validity. If we say, for example, personal law, if you try to understand Indian Hindu personal law differs, Christian personal law differs, Muslim personal law. So what is the very particularly inheritance and all. If we try to understand these three personal laws, there is a lot of variation. So there is no, but there are some universal principles with reference to marriage, with reference to property distribution, etc., etc. But these historical school people are of the opinion that you can't find a universal validity so far as law is concerned, because it always depends upon some rational promises. For example, if we take French Revolution, they don't believe natural law, so they have shifted themselves to historical school. Legislation therefore has subordinate role. So that means it is the custom that has priority, it is the tradition that has priority, but not the law. But according to our constitution now, which we have identified, we have given the legislation as primary role, customs and traditions secondary role. We modified it according to our requirement. Custom is the typical form of law, the sanction behind custom being the habit of obedience, social standards of justice. So historical school believes that legislation is secondary. As society advanced from the primitive stage to a more developed stage, with all the attendant complexities of modern civilization, vogue gist alone cannot discharge the function. That means will of the people alone cannot make a law to have its evolution, development, etc. But law is now fashioned, molded, articulated by virtue of the history the respective society has undergone through. So French Revolution, the history made them to enter into phase of French Revolution. Now subsequently post-French Revolution, they are trying to update their laws. They are trying to make the property available to the every individual, not being concentrated in the capitalists. So that is what the historical school believes. Legislation appears at the final stage, and hence preparation of code presupposes generations of jurists who clear the ground for it. So if we take the example of, for example, Consumer Protection Act 2013. So, 2020, Consumer Protection Act 2020. So to have that legislation, we have worked for 10 years. So generation of jurists worked a lot, and that is how we ultimately given the shape. Legislation is a final stage. Historical school believes in that particular perception. So that is how Mr. Savigny and various other jurisprudence, by believing the vogue gist theory to a considerable extent. Vogue gist theory means the will of the people, and accordingly taking the history, traditions, customary practices into consideration. They said that without the historical perception, law cannot survive on its own. So law gets developed by virtue of the history, by virtue of the surroundings. So here Henry Main's observations are discussed here, and that is how the historical school believed that the history is the backbone of the any legal system, and it is the surroundings of that particular country which made the respective country to develop its legal system. So he framed a hypothesis concerning institutions of legal growth in various societies. He suggested the stages of social development. He evolved out a correlation between growth of the centralized government and exclusion of the liberty. So Main's theory of status to contract. Status to contract means the common man will try to have some kind of obligation created to the society. For example, we the people of India gave ourselves, and accordingly we have identified that state after election shall formulate the cabinet under the prime ministership, then president shall be there, the cabinet should advise the president, etc. Is this not a kind of contract which we are having? So status to contract. So our status is now has taken the shape of a constitutionalism, where the state has to follow the directive principles. So that kind of proposition is nothing but status to contract. So we gave the governance to the country, governance to the Indian country which will be elected from time to time. President will be elected from time to time, prime minister, so on and so forth. And the officers will be chosen to support the respective legal system. And that the concept has now taken the shape in the 20th century with the perception of the historical school. So because we were the colony of Britain, we had the British legal system adopted to a considerable extent, having chosen various other features from various other countries. From various countries, from one country we adopted DPSP, from one country we adopted right to life, fundamental rights, so on, so forth. But of course, there was a criticism also against this historical school, stating that Pollock, while criticizing Maine's view, states that his theory is limited to loss of property only, because personal relations, marriage, minor's capacity, etc., are still matters of status, not of contract. So he is of the opinion that, of course, can a minor enter into a contract simply because he feels him? No, he is deprived of. We don't allow him to enter into, we don't allow a minor to enter into marriage, because we are of the opinion that the consequences that would arise on account of minor's marriage or minor's contract, it cannot be sorted out, and the minor should not be imposed with burden, all these things we think of. So because of that reason, Pollock criticizes that it is not the status of contract that will work out, because the minor people and all, they may not be entering into, or they may not be permitted to enter into. For example, if you take the Indian population now, there are so many children, there are so many people who are incapacitated to choose a particular government. So children not having right, even then those children are governed by the respective state. So in that case, this status to contract will not be holding good. That is what the major criticism against the historical school. Moreover, individual freedom of contract is curtailed by social legislations. Yes, of course. So we are prescribed some wages, we are prescribed some working hours, and we are prescribed recently during this corona, even our movements were also restricted. We were arrested, house arrest also. So those who are contacted with corona, they were kept inside, and they got their gate were closed, and the lock were kept with by the health authorities. So all these things, because it is not possible on account of the social scenario, that is what status to contract, that is not going to work out according to Mr. Pollock. The thesis of Maine denying the title of conscious legislation is disapproved by intense and still unabated legislative activity, so which provides conscious direction and many a time reserves the deeply rooted trends in the society. So the society may not, sir, yes.
దీనిలో ఈ క్వశ్చన్ లో మనం ఒకసారి తిరిగి ఉన్నాం, క్వశ్చన్ కన్ఫ్యూజ్ అయిపోయినట్టున్నా ఒకసారి.
ఓకే 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 రండి ఒక్క నిమిషం.
దాని మీద క్వశ్చన్
అదే ఒక్క నిమిషం వస్తున్నా. ఇది కదా, ఇది ఈ క్వశ్చన్.
Which of the following juries is not related to historical school? Okay.
So we found Savigny there. We found Henry Maine. We found Hegel.
So Elrich is the only one.
Yes. So he is not related to historical school.
ఈ స్కూల్స్ చదివి బట్టి పెట్టడమే చాలా కష్టంగా ఉంది.
కొంచెం బేసిక్స్ వరకు గుర్తు పెట్టుకోగలం తప్ప we can't remember the entire thing, but basically we can understand. Yes, this is the basic tenets bulke. So basic tenets ఇక్కడ మళ్ళీ వచ్చాయి చూడండి, you can remember. So law is not an abstract.
ఇంకా మొదలెడతా చదవటం ఇవన్నీ.
Yes sir. So
ఇవాల్టికి చాలు మ్యామ్.
Okay sir, okay. So we'll close here, and the rest of the questions we'll discuss tomorrow.
Yeah. Okay. Thank you very much.
Thank you sir.
Thank you.
Right.